Welcome to another episode of the X-Files, the Divorce and Separation podcast with me, Alex, family lawyer, and my esteemed colleague, Liza Friedwald, also a family lawyer.
How are we all going today? For those that are new to the podcast, we are the X-Files Divorce and Separation podcast. It's available on all leading podcast platforms and even YouTube.
Just before we get going, the usual disclaimer, which is this is just you and I having a chat about family law stuff that we see, and maybe to give some people some helpful information if they're going through a situation that's relevant, they've gone through a separation, or maybe they know somebody who has, or maybe they're just interested in this topic and this area of law. It's information only. It's no legal advice on here. If you need legal advice, reach out to me, reach out to Liza, or if you have your own family lawyer, contact them, because it needs to be very specific for your circumstances. Professor Google and all the podcasts in the world do not know your situation. And so get proper legal advice. That's the boring stuff out of the way. Today's topic is a continuation of the property settlement journey that we've been talking about. Now, we've talked about what to do in the immediate aftermath of separation. We've talked a bit about the stages, the 4-step or the 5-step process of reaching a property settlement. And we've talked about some of the mistakes that we see, common mistakes like forgetting about time and dates and not doing disclosure or getting the values wrong and things like that, and doing things on the back of a bar map rather than formally. But today I thought we would look at the pathways. So we've reached our deal, and that's really just the beginning, right? From our perspective, the handshake, metaphorical or otherwise, or they're no longer growling at one another and you've reached an agreement. That's the starting point for what comes next, isn't it? So
this is what this episode is targeted at. What do you do when you're amicable enough that you've had those discussions and you feel like you're on the same page? How are we going to actually formalize? How are we going to get you to that final stage of being completely separate and on your way? That's what we're here to do today.
Yeah. So it's a lot about formalizing the process and making sure that the deal that you think you've got is the deal that's actually been agreed in the mind of the other person. We often get clients come to us and say, oh, it's all done. This is what we've agreed. And then you write to the other person, or if they've got lawyers, you write to them. And they go, no. That's not agreed. No, we didn't mean that. Which draws you into sometimes a little bit more negotiation.
That's right. And so it doesn't mean you're running off to court straight away just because you both don't agree. There might be a very small point. You might have been able to reach an agreement of a 60-40 split, but you haven't quite resolved what that's going to look like. Is there going to need to be a super split amongst that? Is there going to be more cash coming your way? They're the sorts of things that maybe some more negotiations that are going to have to happen.
It might be partially agreed. I mean, people might say, no, we're going to go 50-50. What they mean is they've decided to sell the house and they'll share the proceeds 50-50. But then if one of you's got a bumper superannuation balance compared to the other person's very small one, well, that's probably not going to get past the court in some ways, if you need a rubber stamp on that as a court order, because it might not be fair, might not be just and equitable.
Yeah.
Likewise, if you're having it in a financial agreement, your lawyer's going to probably write you a letter saying, this is bad for you. You shouldn't be doing this, and makes you have a pause for thought. So that negotiation is like that. The negotiation after the agreement, I know it sounds a little bit perverse, is to get the details knitted out, is to say, well, this is what we think the property pool looks like. If there is a real big imbalance in superannuation, you just mentioned a superannuation split, that might be needed. And what we mean by that is you can, in family law, have an arrangement that's through an agreement or through court orders that says from the husband's super, for example, we're going to take an amount from that super and put it into a super pot for the wife instead. That can happen. You can transfer that. That can work. The various superannuation funds have different mechanisms and ways of doing it, but they're all very, very similar. But your family lawyer can draft the provisions of the agreements or the orders that are necessary and that comply with the Act to do that. You might have other things. The law changed in relation to the treatment of the family pets fairly recently, and that's something that sometimes needs to get expressly dealt with. They're now referred to as companion animals in the Act, and there's different considerations. But we're talking mainly about people who've reached an agreement. So, you would hope that the arrangements for Tricky Woo or for Rover or for, Tiddles would all be known and understood. But if not, you probably want to get those written down somewhere. These are the little things or not so little things.
They are. There are two main ways you can do that, I think. And that is if you have that relationship with your former spouse or partner that you can negotiate yourself, it can be the more cost-effective way to do it. And touching upon a previous episode where we were talking about things like not waiting too long before you go get legal advice. If you've received legal advice ahead of that conversation, it can actually empower you and educate you enough to be able to go back and say, right, we've forgotten about Rover. We've forgotten about this, we've forgotten about that. We need to include these things into our agreement. And what that in fact does, it will save you some money because you're not having to engage the lawyer for those other parts of the negotiation process. So you're not getting your lawyer to draft the letters back to your former spouse that you can probably have those conversations with. So if you get that advice first, it gives you that option of whether you want to do the negotiations, or if you don't feel comfortable, you might want to engage your lawyer to continue those negotiations. Just think about it like when you purchase a property. You say, I want to buy that house for that price, but there's usually some negotiations in relation to the terms of the contract afterwards.
Absolutely. Look, I think the good advice there is to get advice early. It doesn't have to set you off onto a path for war. Quite the opposite. It can say, these are all the things you need to consider. Make yourself a list. Here's a little bit of an action path. And if you are able to have a civil conversation with your ex, that's fantastic. And get documented as much as you can, reach as much commonality as you can. You might not still be able to agree about everything or like the final number or something. And that's kind of where you might say, okay, well, we've gone as far as we can go. What would you recommend that they did next, Liza?
The next thing would probably look at a mediation, some kind of dispute resolution that doesn't involve the court, because again, we're dealing with parties here who are wanting for a number of reasons, whether it be cost or just trying to preserve whatever relationship you do have with your former partner or spouse. Remembering that not every separated couple needs to be at loggerheads indefinitely with one another and hate each other's guts forever and a day.
No, it doesn't have to be a war that goes on forever. It's just that relationship didn't work out. But
particularly if you have children, it's in your interest and in the interest of the kids for you to be able to appreciate that your adult relationship is over, your co-parenting one is just about to begin, and that you need to do all things that you possibly can in order to preserve that and not damage that relationship for the sake of your children. So a mediation is a process where you've got an independent third party who is known as a mediator, and they will assist you and guide the both of you through having some discussions about where are the parts that you need some assistance in trying to reach that common ground and coming to a resolution. And so those sorts of processes can be really, really useful, particularly in the early stages.
I find mediations to resolve so many matters before they become litigious. It's a very, very worthwhile pathway. If there's no elements of, as you say, control or violence, and it's two people who can't quite agree on what the final outcome should look like, then, yeah, I think a mediation is an excellent way to proceed. And it sounds all a little bit sort of touchy-feely, huggy. It doesn't really work like that. It's more...
You haven't been to one of mine then?
Yeah, no. It's more of a structured negotiation with the help of a mediator. And you get different styles of mediator. There are evaluative mediators, there are facilitative mediators. But if you're taking your lawyer with you as well, which is often a very good idea because they can draft the documents there and then, and be on hand to give you specific legal advice, that won't work, or you could do that, then you can get it done in a day. And you can have everything kind of resolved. If you're fortunate enough to reach an agreement early enough in the day, you'd be able to even draft the consent orders themselves.
That's right.
And have everything literally signed and packaged off and even sent off to the court by that afternoon.
That's what I normally do. On the off chance that you are actually going to resolve it, I'm busy drafting up your orders and then you're done. You haven't wasted that time. In fact, you've got extra value during that process.
One of the very good reasons, if you have a clear understanding of what's involved, the pool's all certain, and it should be before you do this. Taking your family lawyer along with you to that on that process with you, so they can draft the documents there and then.
That's right.
Even if you've got complex legal arrangements that might need third party involvement, you can have enforceable heads of agreement drafted up if you take your trusted family lawyer with you and have them do that work for you. That's what they're for. That's what we are for. That's what we do.
And just before we move to the next topic, you mentioned those where there are family violence issues or control issues. Bringing your lawyer along to the mediation can actually help negate those sorts of issues. There is an exemption in relation to filing of court proceedings, of proceeding without having gone through a mediation process if parties have got allegations of family violence. And people sometimes think, oh, well, I've got a history of family violence and I've been the victim of domestic violence all these years. I couldn't possibly mediate. And I say to that you are the perfect candidate to mediate, because if you are the victim of such control and abuse, there's nothing stopping that person from continuing that abuse through the legal system, dragging you through the courts. So the mediation process is a process that's designed to give you back your power. And your power is in the form of you making your own decisions, not having anyone else make them for you. And if you bring your lawyer with you to that mediation, you've got your lawyer in your pocket, you've got someone there who is there to support you and to set the record straight and to say those things that you may not have the guts to say. And you may feel that you'll be shut down. So to those people
and to be your mouthpiece as well, your sort of little champion on the day.
Totally. And to those people who think that they can't mediate because they've been victims of violence, make sure you just get your lawyer to come along and be that person that you need.
Yeah.
Because you don't want to be missing out on that process just because of that.
Because if you take take the pathway towards an early mediation and that resolves your dispute, wow, you're one of the fortunate ones, because getting dragged into a litigation, it's very expensive, it's very uncertain, and as you alluded to a minute ago, and I'm reading increasingly large numbers of articles about this, about the misuse really of litigation to continue on with that pattern of controlling behaviour. Now the courts are in an invidious position here because they have their protocols and their pathways and their practice directions, and they must follow all of those. And then if you have a party who is trying to make it more difficult, it's frankly the rules and the practice direction, they allow, there's a lot of space in those for you to be able to make this case much longer, much harder, much more expensive. And then if you are, for example, the person who has been beset by control abuse, it's going to seem never ending to you. And it's incredibly expensive. So where you can, absolutely, then mediate, get it over with, and get on with your life. It's much better. And hopefully, as you say, if they're the parent of your children, you'll have a better parenting relationship if you've walked away as grown-ups and you've done this early in the piece.
Totally. And then you've got to work out, if you do resolve it, which way you're going to resolve it. Are you going to do a consent order or a financial agreement?
Yeah, well, that was the next question really that I had for you. So we're only talking about property today, but I mean, we'll touch on parenting another day, but there's another option there around plans. But so for property, if you want to formally reduce this into a legally workable document in Australia, then it's court orders or it's a financial agreement written under the Family Law Act. Those are the only two ways to do this properly and structurally. So let's talk about court orders then first. Doesn't necessarily involve having to go off to court.
Yep.
You may never see a judge. You may never step inside a courtroom, but you can still have court orders made, and we call those consent orders. When everybody agrees to the outcome, the documents are written up. Here's a list of what's going to happen. Here's an application form that sets out who we are and what our background is and what the property is that we have, and if we have them, what kids we've got, and so on. And here are the orders that we want. If the court looks at that and says, yeah, that looks to be appropriate, ties in with the legislation, then they can make those orders, and they'll be as good as if you'd fought over them for 2 or 3 years and spent a fortune getting that far.
And the alternative to the consent order, of course, is a binding financial agreement. And sometimes you might consider a financial agreement as the preferred option if there's a few different things that might arise. One is you've reached a commercial agreement and it may not necessarily be considered just and equitable. Okay. And that's not to say that someone's ripped the other party off. Sometimes it just may mean that there's not that much there in the property pool. There's a sizable amount of super. One party is keen to keep all the super. One party is keen to keep all the cash, and the parties are generally okay with that. Sometimes you might get pulled up by the court for those sorts of things because they think, oh, that's not fair that party B has to wait until they're retired to get access to their super. So you might think, well, if it's outside of what we would normally consider as just an equitable, we would recommend to you that it be a binding financial agreement.
And certainly sometimes people have got diverse or more complex business interests and arrangements. It can be more helpful to give you absolute control over that by saying you might need to work with your business partners. Say, look, my ex is entitled to some of this, but it might not be for a period of time. And so you can factor in slightly longer term things in a financial agreement that you might otherwise do with a court order. The courts are beloved of finality. It's written into the legislation. There should be, wherever possible, finality. And sometimes with long established family businesses where both of you have played a part, that might not really suit what you're looking for. You might want to be crystal clear about what your obligations and your entitlements are, but you don't necessarily want to sever, at least immediately, that relationship, because you might have some lucrative business that you're doing over the next year, 2, 3, 4, 5 years. So financial agreements give you a lot of flexibility.
Yeah, in terms of what you're trying to do, when most people split, it's usually to the party's detriment. There's hardly any cases where a split sees people financially better off, because instead of you getting the benefit of a combined pool, you are now formally splitting. And so sometimes we have to get creative with the way that we come up with a solution as to how both parties are going to win. And that particularly occurs when there are kids and where parties are amicable and they don't necessarily want to throw everything away, but they just don't like each other anymore and they need to be financially separated. So sometimes a financial agreement can in fact overcome that, because you can set out a whole stream of recitals within that agreement to explain what's going on, understand what the position is, and having all these additional agreements, not so much a condition of the financial agreement itself, but at least associated with the implementation of that agreement, which the court's just going to go, this is all too much. We want you finally financially separated. We want you actually separated. Whereas, you might have some joint venture agreements. You might have a co-ownership agreement. You might have other things that are going to come up.
Yeah, you can still be joint venture partners in business that you've set up whilst you're in a family and continue those on post-separation, go and live different lives with different partners, but you can still be mutually respectful of the other. But it's a very good reason to put that into a financial agreement to give you both clarity. I think it's an excellent use of the legislation. That's what it's probably there for.
And
one of the many reasons.
Well, there's also spousal maintenance too. So if you're a party who is potentially needing some spousal maintenance, or if that's part of the agreement that's been reached between you, you may want to have spousal maintenance incorporated into your deal. The consent orders aren't going to be the pathway for that. You'll need to have it in your financial agreement.
Or if there's no property, but you agree on spousal maintenance, you can have a standalone spousal maintenance agreement. You can do, for example, have some consent orders that deal with some specific property and there's no complications involved. So consent orders are great. But maybe there would be a need for some spousal maintenance for a period of time while somebody retrains and gets back into the marketplace. And you most likely think that's probably fine and fair. And the best way to do that is a simple spousal maintenance agreement if you're not going anywhere near a court.
Yeah, but we just have to be careful with the financial agreements, those binding financial agreements. That's not something that would be able to be done that day. So if you're going off to the mediation,
good point.
If you're wanting it finalised that day, the only thing that you could probably do in terms of signing things off would be the consent order, because there are strict rules around binding financial agreements in terms of the advice that's to be given and the ways in which a financial agreement can be set aside. So they can be a little bit risky if you don't get the proper advice on those.
That's right. The litigation around financial agreements tends to be where they've been rushed or they've been created when there's a great deal of pressure on one person to sign something and there hasn't been enough time to reflect on advice even. So the advice might be, for God's sake, don't sign it. But they go, I have to sign it this afternoon, and they sign it. Well, the courts have historically disliked intensely those types of arrangements and they'll set them aside. So, Liza, you're bang on. Financial agreements can be a very useful tool, but only if they're used wisely and judiciously.
Yeah.
But not judiciously, non-judiciously.
No.
in the everyday use of the word judiciously, not in the judicial word use of it. Okay, so we've talked about consent orders and court orders. We've talked about financial agreements. We have alluded to litigation and What I mean by that is you try to negotiate, you've maybe been through a mediation, you've then offered each other settlement terms, and you still can't agree. Time's perhaps ticking, and we talked about one of the mistakes people sometimes make is to let things go for too long and then they're out of time. You may be forced to litigate, and that means bringing an application before the court, doesn't it?
Yeah. It usually starts in Division 2 in the Federal Circuit and Family Court of Australia, for everyone bar Western Australia. In terms of that application, there are a number of pre-action procedures you do need to follow. The best port of call is to talk to your lawyer about those, making sure that you have in fact complied with that. And they are things like the disclosure and attempting some kind of resolution process.
The quickest way to do it, perhaps, if you don't have a lawyer or are a bit reluctant at this stage, jump onto the court's website and they have those publications on there. And then if you've got any questions, you can shout out to myself or Liza or your own family lawyer in your state or territory. But it's processes that you must go through now. These aren't optional for you. You've got to try to resolve things without going to court. You've got to be open with your disclosure. You've got to try and put offers together with one another. But sometimes none of that works, and you do end up having to file proceedings, and then, lo and behold, you'll be finding yourself lodging documents, affidavits, and financial statements, and all of these things.
Anyone who knows me knows I hate forms. I really do. I cannot stand completing forms, but anyway.
It's the bane of our lives, but the courts have made a raft of forms that we have to fill in. So that's what we do. We fill in those forms for you, and we'll get those lodged for you, and then there'll be a court date.
Yep, it's usually about 1 or 2 months after
and you have
filing.
to then send all of those documents through a process server, or if they've got a lawyer, from lawyer to lawyer, to the other person, so that your ex knows about the case. They've then got a certain amount of time to file their documents in reply, if you like. And then you come to your first court date, and unfortunately, I wish I could say, and it'll all be over at the end of that day, but it won't be.
That happens.
It's a procedural hearing date, the first court date. Now, we don't have enough time in this podcast episode to go through the life of a court matter as if it had conducted every way in the right way, but we might look at doing that to tell you, here is the court pathway as it should go if you end up from beginning to end. But just know that if you start the litigation process, if you've been through the other ways of trying to resolve it, it's the longest, it's probably the most expensive, and it's the most stressful avenue, but sometimes it's the only way that you've got to get it resolved. So don't shy away from it. If you have to do it, mount up, get yourself a lawyer that you feel you can work with and that they have similar values to you. Try and resolve things constantly as you go through that process, but know that except in the rarest of occasions, when you reach an agreement after having filed proceedings, you won't get everything resolved on day one. And I've done it. I mean, we do a lot of video appearances now for those first court dates, but certainly pre-COVID, when we were all hustling around outside a courtroom for the whole day for a 10-minute appearance in front of a judicial registrar or somebody, a judge, you would inevitably spend a lot of the time talking to the other person's solicitor. And sometimes you could work out a whole deal. It was almost like a quasi-mediation compelled upon you because you're there. So I think we miss out on that a little bit now. But
yeah, we do. While we're talking about the pathways, I just wanted to mention 2 additional very brief points. And one is that if you've got a smaller property pool, I think they call it the Triple P pathway, which is the priority property pool. That's for cases where the pool's under $550,000. And there's also another option, which is an arbitration process, which you can either do through the court system or you could do external to the court system. I do a lot of arbitrations. I believe in that process, particularly given the court's delays with property matters that you're usually looking at as a minimum a 2-year wait time for property matters. So if you're wanting to get in and out of the system, an arbitration is another alternative, but we're going to touch on that in more detail in an upcoming episode. Just to recap, the overall takeaway from this episode is really negotiate where you can, mediate as soon as you can, and as soon as you have enough information to make those informed decisions. And if you do get stuck, there's nothing stopping you from mediating again. You don't have to just say, oh, well, we must be off to court now. Mediate as many times as you need Court should be a place of last resort, particularly if you have children, and formalise that agreement so that you don't have each other coming back at you in years to come. Okay?
Very wise words. And that probably wraps us up for the Pathway episode. So for now, not legal advice, just information. Hope you enjoyed it. Let us know any questions, and thanks for listening.
Thanks, guys.